I have a question with one of the submissions you shared, the RESMA, commercial agencies, which at the court of a first instance was a dispute between a wife and a buyer, and the allegations were that the husband had disposed of matrimonial home to a neighbor, and the court had the first instance had actually held that that was matrimonial property. When it came to your court, the majority of the bench, while making reference to decided cases, including those in the UK, you held that, I'm just giving in summary, that marriage or occupation of matrimonial home does not in itself create ownership rights. A spouse must prove direct or indirect contribution on acquisition or improvement of a property. Reading through the decision, my lord, I took note that the wife, though deceased then, had given evidence at trial how she operated a shop in Nyahururu, how she was engaged in farming activities. She cultivated crops, kept livestock, and out of this engagement, the money she got from this enterprise, she was able to improve or invest part of the money into in enhancing the construction of the building and developing the property that was a family residence. And when the husband, her allegations are that when the husband was unable to meet his obligation as the man of the house, quote unquote, she assumed financial responsibilities, including paying school fees for the children from the proceeds of the commercial activities. In this matter, Judge Professor Ngugi dissented, and his argument focused that courts should also consider the oral evidence and the surrounding circumstances and the real lived realities of informal economies, domestic economies, so that courts are cautioned against focusing so much on strict documentary requirements. And Judge, as you rightly say, courts should look at the plight of Wanjikos, Otienos, and Aminas. The real realities of most women in Kenya is that they don't keep receipts. They're involved in informal economies, in the market, in the supermarkets, or informal workforce. So by you I respectively disagree with your decision that the wife ought to have proven the non-monetary contribution. So the decision, I find it creating a tension between certainty of title and equality within marriage. So this buyer had a title, and you found that he was a buyer for a bona fide purchaser. And how should courts then balance evidentiary certainty? Most women do not have receipts, and the Matrimonial Property Act speaks of the non-monetary contribution. So how should courts balance the evidentiary certainty when it comes to matrimonial property law and the principle or the constitutional requirement on equality? That is one question. And still on that, if appointed as a Supreme Court judge, how would you reconcile again the issue around strict procedural requirements with the Constitution transformative mandate to protect matrimonial property and understanding the lived realities of most Kenyan women? Thank you. Sorry it's wrong, but I think you understand the gist.
Thank you, Commissioner. I think that's an excellent question. I look at it from this perspective. in every decision, it is the parties who know the truth. The judge is in the dark. Secondly, in my court and in my career, I have to do justice between the parties. And how do you arrive at justice is looking at the evidence critically and whether a case has been made in respect of a particular proposition. Here is the case was not about matrimonial dispute. It was under Section 17 of the Married Women Act of 1882. There was no divorce between the couple. So what was before court was a declaration that she's entitled to half or 50% of the property. These couples, from the evidence on record, they got married in 1970. At the time of marriage, the lady was working. She had a business. And then thereafter, she was employed. The man was also working. He was working in a garage, but later he was employed in Kenya Post Office. They went to various places. But as they went to various places, there was one constant thing. The lady had her own separate businesses. And the parties acquired properties separately. For example, in the Nyahururu house, or the Nyahururu property, which was 5 acres, that was their original matrimonial home, where they kept everything, the chickens, grow something. So that was the original matrimonial home. It was registered in the name of the lady. After retirement, the man bought a property in Nakuru, which is the subject property. In the middle, he was unable to pay the loan. And they also had separate businesses. They had 3 hotels in Nakuru, in Eldoret. The lady has her own, he had his own. The lady has her own shop, also in Nyahururu. She was selling other businesses. So it is not like an ordinary, informal women who were engaged, who could not account. She had a bank account. For example, when the property in Nyahururu was sold, she banked the 500,000 in her account. And when the man asked for money to offset the loan, the lady did not pay. What happened? What happened is this. This man was sick, from the evidence on record. He was unable to buy medication. His eldest son was also living within the premises. He was threatened by his eldest son, who broke into the main bedroom. There was fracas in the kitchen. This is all evidence. And as a result of his financial position, he decided to sell the property. When he was selling the property, he shared that information with the wife. And this is evidence from when the demand for rent was made. They went to the people, the RESMA people, and asked for time. And the question arose whether they should be given 1 month or whether they should pay 13,500 or something like that. So it is not a question whereby the man sold the property behind the lady. So she knew that this man was selling the property. Again, 1 month after the transfer, and 1 month after requesting to be given more time, the lady filed an injunction. And she got an injunction. 1 month later, the case, the man took the position that the lady knew that he was selling the house, he was selling the house, and that they have agreed to build another property in a place called Mwariki, Kiambogo, and that is in evidence. The man wrote a very comprehensive affidavit when he was sued together with Resma, and said, all along my wife knew, and I sold this property because I was in financial needs. I could not buy even medicine, and I was sick. And I was buying because my son wanted to burn this house. That is the evidential position. And he says this man is innocent buyer, and we have the money. 8 years later, after the death of the lady, the man now signed another affidavit and said, I have sold the house, but I want my family and my children to inherit it. But I am willing to pay 15,000 shillings per month to refund the money. The case was handled by many judges, including the Honorable Chief Justice at one time. Maybe she doesn't remember. Way forward, it is not a case of where an ordinary lady who could not provide documentary evidence. These are two parties who had a separate life, separate properties. And what is the role of the court? The role of the court is to look and stand between the parties. Here is Resma, who bought this property, but who could not get his money, even when the judge ordered and say, keep the house, but refund the money. No money was refunded. Even when the matter came on before us for appeal, we asked, what is the position? Can you have a settlement? The answer we got is that give us judgment, Resma can sue. And when we ask, they sue who? They sue the person they want. So I fully understand the responsibility of a judge in terms of acquisition and distribution of matrimonial property. And I have dealt with many matters in the Court of Appeal in terms of such kind of dispute. In fact, this matter which we have referred to, which is also a leading decision on matrimonial distribution, was certified by myself and Commissioner to go to the Supreme Court, the JAO matter. The JAO matter, and we raised pertinent issues, whether, for example, Article 45.3 is an automatic 50-50 apportionment. And all these circumstances, and when we have looked at the analysis and the evidence, we have arrived at this man was an innocent purchaser in the circumstances of the case. I am alive to the fact that there are certain documentary evidence in an ordinary rural life which cannot be accounted for, and they may amount to indirect contribution. I have several cases in the Court of Appeal held that this is the way to go. But this is not an ordinary case. This is where parties kept their businesses separate, their property separate, and the lady knew this man sold the property. This is an information correct?
Okay. Thank you, Judge, for that clarification. Though from the reading of of your decision, it appears that was the matrimonial home, and the property that was sold in Nyahururu was supposed to be used to pay off a mortgage, but the husband decided to buy businesses in Eldoret. But I'm happy with when you say that you normally consider non-monetary and monetary contribution. Then which one do you give more weight? Which one would you give more weight when it comes to monetary and non-monetary contribution, when it comes to acquisition of matrimonial property?
You know, my position has always been, this is not about mathematics. It's about the significant and substantial contribution of a lady or a man in terms of acquisition, management, and the division of the property. It is not mathematical, but there must be evidence that one party contributed, whether indirectly or directly, substantially. There are instances, for example, where the lady, as a result of her indirect contribution, gets 70 or 60 or 40%. Look at what we have said in the Rubia case, for example, which I was involved. Look at what we said in the Virginia case, which I was also involved. So it is not a standard to say this is the correct formula. And the problem, in my view, is not the evidentiary. The problem is structural. Why is it structural? The Matrimonial Property Act even was unable to resolve that issue. And say, for example, it says under, is it 7? If there is an agreement, this is the mode of distribution. So the question is the discretion given to the judges. And as judges, we weigh the evidence, and each particular case has its own peculiar circumstances and evidence. Cases are not the same, but the circumstances in this case. Look at, for example, even my brother, the dissenting judge. If you read his judgment, of course, dissent, but in my view, to give the Supreme Court an opportunity when such a matter arises, I was saying, and I will say, this is the amount I will give to the lady. For the Supreme Court to start from a premises, this is what the dissent says. Therefore, we either reduce it or give it. And that is how even on damages, that is how even when you are dismissing the case, which is on damages, you give, such that you give the Superior Court an opportunity to assess your position.
Okay, thank you, Judge. And I do commend the bench in the Elizabeth Wanjiru Jonjo Rubia, where you, as you rightly stated, where in a succession matter, which is silent, the law of succession is silent on whether you can address the issue of matrimonial property in a succession matter, and in your bench you are able to give a widow 50% of the property, despite the law being silent on matrimonial property.